top story now. Another shaky day in the Meyiwa Murder Trial. It's been a back and forth between lawyers for accused 1 to 4 and 5 over the merits of the new docket number 375. TT Tobane, counsel for accused 1 to 4, says the letter from the National Prosecuting Authority on docket 375 is problematic. Let's go to our reporter Silindelo Masikane, who's monitoring those proceedings for us. Let's take you there live. Sli, so a little earlier on, Tsepo Tobane saying that there is an issue with the letter that the National Prosecuting Authority emailed, I think, a few weeks ago or last week. Tell us more about the specific problem that he raised.
So, of course, we're seeing another somewhat of an administrative session in terms of the Meyiwa Murder Trial, where we were, of course, expecting the resumption of cross-examination of Sergeant Thabo Mosia, who was in court this morning, but, of course, has been excused because of the application that's been made by Advocate Zandile Mshololo for accused number 5. Now, when we began proceedings, we had the state handing up a letter from the NPA with regards to its position about docket 375. We know now that this docket is a docket that was opened in 2019. This is a couple of years after the initial docket, which was opened in 2014. That's docket 636. Docket 375 has a completely different scenario in terms of what took place on the night Senzomia was killed. And those who are charged in this docket are those who are in the house. Now, the NPA had written to counsel for accused 1 to 4, clarifying its position on this docket, saying that the DPP of the North Gauteng High Court, who is actually the state prosecutor in this matter, that's State Prosecutor George Baloyi, would make a decision on this docket after the conclusion of this current trial. But the letter that's been handed up to court by the state today in terms of this letter from the NPA actually says something different. It says that the state will actually make a decision on docket 375 after it's actually studied the docket. Now, obviously, the lawyer then for accused 1 to 4 has taken issue with this and has raised it in court. Let's take a listen.
Your Lordship, I'm very concerned, and I agree with the court that 375, the court has made the decision that it is irrelevant with regard to the proceedings of 636. However, if the court entertains the application that is pending of 375, based on 375 docket, it will make it relevant. And even this letter on the 26th of August 2022 then makes it relevant to the proceedings. The state is like playing chess games. They inform the court about this letter but doesn't hand it in. Whereas this letter that was given to us today is different from the one we received by email. And my last submission will be that I'll let representative of accused 5 to continue with the application. Then when we will reply, we'll deal with these all issues from the state side and including that application, Your Lordship.
All right, so we then move to Zandile Mshololo for accused 5 making an application with regards to these two dockets and docket 375. What did she say about her client's constitutional rights?
So now we've moved on to the application where Advocate Zandile Mshololo is arguing in terms of Section 317 of the Criminal Procedure Act. She wants the court to note this, what she describes as an irregularity. Sorry. Irregularity. Yes, in terms of the fact that the state has only disclosed the contents of docket 375 to her in the middle of the trial. So this was, of course, during cross-examination when counsel for accused 1 to 4 had actually introduced docket 375 during cross-examination of Sergeant Thabo Mosia. This is only when Advocate Mshololo then knew that there was a docket 375 which was not disclosed to her prior to the beginning of this particular trial. She says that this has obviously prejudiced her client and prejudiced the manner in which he was able to not only plead but also set out his defense in this particular matter. So she wants the court to note this irregularity so that if at any point this matter then makes it to the appeal court would have noted that the High Court had actually noted this particular issue that she is raising now with the court. She says that the state has basically not done its duty in terms of giving her all the information that's required in order for her to prepare a defense for her client. She says that in docket 375 there are statements, there's the photo album which is being used in this current trial of the crime scene. She even mentioned one particular statement in particular, that is of Brigadier Ndlovu, who Sergeant Musia has on many occasions referred to in terms of the fact that Brigadier Ndlovu was the one assisting him in collecting evidence on that night of the crime scene. So Silindelo Masikane, of course, has now concluded making her arguments. We're going to hear from the state as well as Titi Tobano for accused number 4 after the lunch break. But let's just take a listen.
The content of evidence in docket Foslorus case 37501-2019 ought to have been disclosed to the applicant before he pleaded. The applicant's constitutional right in terms of section 35(3) of the Constitution has been violated in that the applicant was not provided with sufficient detail of the charge before he pleaded. Number 8, as a result, the conduct of the respondent, the state, has rendered these proceedings not in accordance with the law. The furtherance of these proceedings is both unconstitutional and not in accordance with the law. The application is bona fide, not frivolous, and it is not the abuse of the court process. My Lord, it is a common cause and it is evidence before this court that the applicant pleaded before this court on the 22nd of April 2022. And my Lord, it is also common cause that the second docket was disclosed or furnished to the defense counsel in the middle of the trial. And to be specific, my Lord, during the cross-examination of the first witness. My Lord, it is for that reason that this application is brought before this court, in order for this court to record an irregularity that has occurred.
Well, Luxley, I also trip on a lot of words, and what the viewers must understand is that we're not perfect. And I always say to my friends, the English data bundles can literally deplete. But very quickly and lastly, Slee, in terms of Advocate Silindelo Masikane at some point was talking about an opportunity to go through proceedings during this hour break so that she can prepare herself. She says the state received these proceedings or information about these proceedings only now. What was she talking about?
She was talking, of course, about the fact that I think the state, in its reply right now, wants to introduce some proceedings which were done back in March, and there was just a bit of confusion in terms of whether it's new evidence or not. And she was asking the court to allow her to be able to peruse this information that the state said it had also just received before the state makes its submissions on it. So, of course, we will be resuming with this particular application after 2 p.m. this afternoon.
All right, Silindelo Masikane, you've had quite a long morning. Let me leave you to have this lunch break to have some food, water, etc. That's Silindelo Masikane live for us in Pretoria.